As a trial lawyer, a big part of my job is to cross-examine the other side's witnesses, poke holes in their story, and make it seem like they are lying, whether or not they are. In this video, I'm going to be explaining the number one way that you can get falsely accused of lying even when you are not. My name is Veronica. I'm a lawyer here in California, and I help people put their cases behind them so that they can enjoy their lives and their futures. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything that you need to know to win your restraining order hearing, including making sure that you don't get caught in any lies and that you can show the judge that the other side is lying. So if that is something you're interested in, you can get your free first class via the link in the description box down below. Okay, the best way to show that someone is lying, unless you have hard evidence directly contradicting what they're saying, is to catch them in inconsistent statements. So if they change their story, if they change details of their story, if they leave a detail out that they provided another time that they told the story, if any of those details change, then you as a trial lawyer want to do three things. First, you want to get them to agree that whatever fact was changed or left out is important. This avoids either them or their attorney being able to minimize the importance of this fact later. The second thing that you want to do is get them to say that they are sure about whatever fact it is. You want them to say that there's no doubt in their mind as to whatever their statement is. This is again to eliminate wiggle room so that they can't say later, oh, you know what, I wasn't really sure. And then the third thing you want to do is confront them with the fact that they either changed this fact or they left it out in a prior statement. And so what do you need as an attorney to be able to do any of that? You need multiple statements. The more statements, the better. Recently, for a restraining order case, the opposing counsel, they take the case and their client had already filed a restraining order on her own. She wrote it up herself with the help of the self-help clinic. What do? The first thing that they do is they create a new statement for her, talking about the same thing, but changing some of the facts, adding in more facts. Good idea? I don't think so. I don't think so at all. I think that that first statement that she wrote, she's kind of stuck with. And if you make a new statement and you submit that to the other side, well, you're giving me a gift, because now I can compare the facts and I can say, okay, before you had an attorney, this is what you said. Now you changed it to this other thing. And actually they did that 2 more times. Oh, we got this detail wrong. So now I literally have 4 different written statements, plus she's going to testify in court. So now we have 5 statements. The chances, if you talk about the same thing 5 times, of getting it exactly right every single time, it's not going to happen, right? You could be telling the truth, but you're probably going to get some details wrong. So what you generally want to do is avoid giving more statements than you need to. This is one of the reasons why attorneys tell people, don't talk to the police, don't give a statement to police. And people do it all the time. I have clients who are really educated, really smart, but they will still talk to the police. The police put a lot of pressure on you to talk to them. The problem is that if they make a statement to the police and I can't get that statement tossed and I don't like what they said, maybe they got it slightly wrong, maybe the police tricked them or got them to agree to something without them fully realizing, I am stuck with that statement. I can't change it. If the client said, I wasn't there, it wasn't me, I can't argue later self-defense and be credible. And if they were to get on the stand and they were to testify, if they change any of the details of what they said at all, or if they come up with some new detail that they didn't give initially and they had ample time to give their initial statement, well, that is not going to look good for us. In car accident cases, okay, so you are going to give a statement to first the police when they come out, right? Then your insurance company wants a statement. Maybe the other insurance company wants a statement. Then there's going to be a deposition. Then there are written discovery responses. And if you change your story, if you change important details of your story, the other side's attorney, a trial lawyer's job, is to point that out and to make you seem unreliable or more likely that you are lying. And now, sometimes you can't help it and you have to make a statement, or it is in your interest to make a statement in litigation. Maybe you're going to have to end up making more than one. So in civil cases and personal injury cases, you are going to end up very likely having to make more than one statement. And so what you want to do is you want to make sure that you give short answers when possible. Don't add in extra things. The times when it is easiest for me as a trial attorney to catch people in lies is when they're long-winded. They get asked a question and they go on and on and on and they start adding in more details. Maybe they start exaggerating. It is going to be that much easier for me to find inconsistencies in their statements. Sometimes they'll get asked a question by their own lawyer, and I will ask the same or a similar question or ask to confirm, and they'll actually change their story right there. Why? I think some people get nervous and they ramble, and maybe they are telling the truth or they intend to tell the truth, but they end up making statements that are inconsistent, and that leads to the other side, to me in many cases, pouncing on them. You should also review your statements. If you made previous statements before you make another statement, if possible, review that. I mentioned restraining orders. It's amazing to me how many people who are filing to get these restraining orders, who write out their story, and many times they write out way more details than they actually need to, so that's a mistake. But they obviously have not reviewed their statement before testifying. And sometimes it's a few weeks, but sometimes even a few months after that initial written statement, and they will testify differently than what they wrote down. So whether it's a statement that was to the police, whether it is in a deposition, whether it's in a prior court proceeding, you always want to make sure that you review those statements so that you remember what you said, so that you do not get caught accidentally making an inconsistent statement when you genuinely are telling the truth. I hope you found this video helpful. If you do have a case in California, feel free to give me a call. You can find my number down below. You can also book a consultation with me there. My firm takes criminal cases, and we are also taking personal injury cases. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.